Hi, this is Besiana at IMG. We're here at AAJ in San Francisco, and I will have the pleasure of speaking with Charles Neville Reese about his experience and his knowledge of legal system. Charles, could you tell me a little bit about why you think it's so important to have a robust jury system in the United States, and what the impact is for both the cases and for the jury members?
Like you said earlier, people nowadays see the jury duty as a burden rather than an opportunity.
Right.
When in fact it's an opportunity for the people to actually be intimately involved in their day-to-day government. You know,
Exactly.
and I think the system ought to make it easier to have jury trials by having more judges. We need more administrative law judges. We have a whole lot that needs to be administered, you know, and taken
Okay.
care of. And the way you have a peaceable society is by having access to resolutions of dispute, you know.
Absolutely.
So if we could have more juries, more judges, more juries, allow people quicker access for different types of cases. The cases like we talk about here, where we have, you know, broad-based implications for people with massive injuries that are just horrific and unimaginable, are a different kind of case. They would require specific other types of handling, where the everyday dispute over, you know, whether somebody took a pile of dirt off of somebody else's land
Right,
could be
right.
handled in a much simpler way, you know, but at the same time still give access to those opportunities, you know, that make a difference.
Have you seen a difference in how these cases are handled when it's decided by a single judge versus by a jury? What do you think are the main differences?
Well, I think judges ultimately try to be fair, but judges are people, you know, and the purpose of the jury really is to give the citizens the opportunity to make decisions,
Right.
you know, and to involve the citizenry. So that's to me the big difference as far as amounts of judgments and things like that, you know, or the judgments. You know, I've done criminal cases and civil cases, and you know, I've never had like some of these guys have had $500 million cases and things like that. I'm generally happy with the way the system works. You know, we have rights of appeal. We can, you know, but we need more jury trials. We need to have access to juries. We need to eliminate, you know, this forced arbitration stuff that takes people's rights away. This is about creating a culture that's providing opportunity to people. The jury trial and the justice system is integral in making sure that that can happen, because that's how commerce is managed, that's how everything is taken care of. So, but you know, in my little town, those are all much bigger concepts than I deal with. You know, I deal with somebody whose neighbor is encroaching on their right to use some land for parking sometimes. You know, these human things that cause people grief and discomfort.
Right.
You know? So, and try to resolve those. You want the best outcome for the people who come to you with their problem. I mean, just think of that dynamic for a minute. You know, you're sitting in your office listening to music, doing your work on a case.
Right.
And you get some phone calls and you're not really, because you're working on your case. And then you get to talk to somebody and they say, hey, I need some help with this. Think that's somebody who, you know, comes to you as a lawyer. You're in a small town, they come to you, and what greater compliment can be bestowed upon the lawyer, you know, than to have someone come and say, here, help me with my case.
Right.
Well, when the
Trusting.
lawyer does that, that's a sacred trust then at that point. That becomes a thing that has special treatment and special being. And you know, I am going to talk about the AAJ a minute, because the people that are here, the people who are a member of the organization and think about the things that we're talking about, are people who are prepared to put themselves on the line in order to obtain justice and economic freedom and safety for other people. And it makes a big difference.
Absolutely.
I mean, it can make a big difference. If we need to take the shackles off of the justice system and get rid of these artificial barriers to people deciding cases. You know, people want to make the assumption, who are against the jury system, they want to make the assumption that the jury pool is stupid. You know, they want to take the worst example of somebody not paying attention. You know, I've been guilty of not paying attention. You know, everybody's probably been guilty of not paying attention, but they want to take the worst example and denigrate the jury pool. Whereas most plaintiffs' lawyers, you know, those of us who want to present our facts in front of some people who can make a judgment, we want intelligent jurors. Because we're not asking people to be unintelligent, we're asking people to apply their intelligence in resolving these issues so people can be compensated for wrongs, especially those wrongs that are done intentionally and when people could have tested and could have come up with different alternative designs, but made the decision to sell human blood for money and injure people. These people that walk these halls, these great lawyers who do these things. There was a great guy named Ted Koskoff, who was a great lawyer out of Connecticut. And he used to talk about the founding of the country and the role of lawyers, you know, and how lawyers are, even though, you know, they're the objects of jokes and denigration oftentimes, are really the heroes that stand between chaos and order, you know, and provide remedies for people.
Exactly.
I mean, how terrible is it to be thrown in the jail of injury and not have the remedy available to get medical care. Not to mention the loss of the humanity of being able to hold somebody close to you and feel that love exchange. You know, how do you replace those things?
Exactly.
And how could we function in a society that didn't afford the opportunity to have redress for those losses?
100% agree with everything you're saying. You mentioned one case that was particularly impactful for you. Do you have any other example of a case that was really momentous for you, or particularly, you know, demanding and challenging and important, that's memorable from your career, of the many?
Well, you know, I mean, I've had stuff go sideways in court, you know, that goes crazy, you know. I was in a case years ago. My client's wife was sitting in front of the jury box and she was crying. And my client was on the witness stand. He was talking about the impact of what some people had done, some lawyers, what they had done when they filed this frivolous lawsuit against him. You know, and the lawyers were sitting behind me and they were laughing. And instead of my client following my instruction of remaining stoic, notwithstanding what might occur in the courtroom, he yelled out, "You may think it's goddamn funny, but I sure as hell don't."
Oh no, you
can't
judge say that in a court of law.
Well, my guy was he was really angry about them laughing.
Yeah.
You know. And
they were doing it intentionally, perhaps.
I wasn't aware they were laughing.
Right.
If I had been aware that they were laughing, I would have been cheering in my heart, because that was just what the problem was. It was that arrogance of power, you know, that was being displayed in the case.
Right.
And anyway, the judge, he's a very good judge, very thoughtful man. He was sitting, and he would sit. He had neck problems. He would sit back in his chair and he would close his eyes and he would listen to all the testimony, and he'd pay a lot of attention. And as soon as my client yelled at him, he popped up. Everybody in my chambers, you know, were
wow. Immediate remediation.
that was a really kind of an embarrassing, odd moment to occur in a courtroom, you know.
It can happen. Do you find often that your clients maybe don't take your advice like that one?
You know, a goose is a goose and a gander is a gander. People are going to be, this is part of the, I think, part of the crucible of truth that exists in front of a jury. A leopard doesn't change its spots. I mean, there are people who can be clever and evasive and all this, but ultimately in front of 12 people, you know, and in the formality of that courtroom, I see courtrooms as temples of justice, you know, and they're in there, and there's something that occurs, you know, and people can discern garbage from the fruit. Sometimes things happen. You know, my guy tended to be a bit aggressive at times, but, you know, I can understand him being very defensive when these people were so callous and, you know, and him not being able to restrain himself.
Yes.
I can understand it.
Did he win that case?
Oh yeah, we won the case.
There you go.
Know, it depressed damages.
Yeah.
You know, it depressed damages.
It did have an impact on the result.
Oh, absolutely.
You won, but not as much as you could have.
Right,
Okay.
right. It did have. And the thing about it, it was a unique theory of liability. See, we have a struggle, a philosophical struggle that takes place, you know, on the one hand, culture really wants a mechanism of resolution, but they don't want the mechanism of resolution to be too powerful and to be abused.
Okay.
And unfortunately, the law doesn't seem to have evolved in a way yet, I think it will, to avoid abusive law litigation, you know, where litigation is being used to grind people down.
Right.
And in that particular case, the theory of liability was the fundamental question that was raised by the fact pattern in that case was whether a person holding a raffle could be compelled to deliver a machine gun, an AK-47 machine gun, to a 12-year-old. Our position in that case was that there was no arguable basis from a standpoint of either fact or law to be able to utilize a court to compel such an outcome, and that the case in and of itself was frivolous on its face, and that as a consequence of that frivolous filing, and as a precursor to that being done, it was necessary that the lawyers, aware of the facts, you know, and that means they have to make themselves aware of what the facts are through, you know, intelligent, objective analysis, you know, and then they have to apply some theory of law that would promote the outcome that they're seeking. And if they can't do that, then the case is frivolous on the face, and they violated Rule 11 of the Federal Rules of Procedure, which requires you to analyze the truth of what you're filing. You know, you're standing there asserting that when you make this filing that there's a factual and legal basis for your filing, you know, essentially under the rule. And my theory was that the violation of those principles, those fundamental legal principles, caused liability not only for the person who was asserting the lawsuit, the primary, you know, plaintiff or defendant, depending, who was asserting the claim, but the lawyers who asserted the claim as well, that they were financially responsible. We went through, in that case, we went through 3 or 4 processes of, I think it was 3 actually, processes of summary judgment, where Judge Hobbs had to struggle with that. And he didn't like the case because he saw what I was attempting to do, which was to create a common law remedy for frivolous lawsuits. So then that way, you know, with clear guidelines of what constituted that finding, and then that way let the common law handle it, not give it to the legislatures who are not educated about it to come in and do a hodgepodge of laws that try to redefine the rights of our citizens, because one of the fundamental rights of an American citizen, or anyone in the country, is to be able to petition the courts, for redress from the government,
Right.
and so these fundamental things have to be protected, and so that
Absolutely.
was really the crux of that litigation. But unfortunately, I mean, the cause of action hasn't ever actually taken off, but I think it's a remedy. I think it's a real remedy.
That's amazing.
I've been very fortunate, because I had a very diverse life as a child. I managed to survive certain situations where I probably easily could not have. And I've been able to practice law for the better part of 45 years, and I'm still in fair physical condition. And as long as I maintain, a level of mental acuity, I would love to keep doing it because I love it. I love being able to have the opportunity to make someone's life better in a tangible way, or even an intangible way. Like the woman I was telling you about before, who came up to me and said,
Yes.
I want to thank you because my daughter told me about her success, and I mean, those things are neighborhood, people-to-people things that have, like you throw a stone into a calm pond, and then the ripples come out, and who knows what the effects of those ripples are, in our people's lives. And if we all wanted to be kinder to one another and help one another, I think we'd have a much better and happier world, don't you?
Absolutely.
I appreciate this opportunity to chat with y'all, I mean, I think the message is much more important than the messenger,
Both, I think. You mentioned about, product liability and companies that launch products with people's blood, that launch them knowing that they would be possibly doing damage. Do you have any examples or history?
Well, I think one of the most classic examples was the Ford Motor Company cases, the cases involving the Pinto. The Pinto cases, they had a memorandum, where they made an equation between cost of repair versus the probable settlements.
Right.
And they made a business decision. I don't know how many companies make a business decision that, they know that they're leaking some toxic material into a watershed, or they go and they cut timber,
Right.
on an adjacent parcel that's not theirs, that they have no right to. I mean, there's got to be accountability.
Right.
And there are people here who have better examples probably than I could give, but the principles are all the same.
Absolutely.
If we're going to put out a product, we ought to do our best to do our best, and if there's
Yes.
if their testing demonstrates that there's a weakness in the product, or if testing should have been done to determine whether there was a weakness in the product, and then they go ahead and put it out anyway and it injures people, then there should be some accountability, to get fair compensation, equal compensation for people.
Absolutely. I love that. We got to do our best to do our best. I love that. And what advice do you have for young attorneys who are just finishing law school and looking to either enter large law firms or begin their own practice?
I see so many of these young lawyers who are coming out. They're very focused on their, moving up, making connections, doing, promoting their careers, staying on top of it, highly intelligent. I mean, my hat's off to them. I mean, they, intellectually, you've got people out here who are giants, intellectual giants, that,
Right.
and I certainly wouldn't presume to give them advice about how to move their careers. I practice by myself in a small town. I mean, it's not exactly your vision of success in the legal world, by a lot of standards,
No, but it's equally as important, because if you weren't there,
That's right.
would they have representation?
Some would, some wouldn't, but the
Exactly.
question is, would they have the quality representation? That's how come I'm still doing what I'm doing. It's
Yeah.
because the people who I've worked with thus far, have believed and have seen that they're provided, caring, quality, honest, legal services.
Yeah.
When somebody doesn't have a case, I'll be the first to tell them they're wasting their time and, focus elsewhere, figure out another avenue in your life, better life plan. When you weigh it all down and ask yourself, where is the crucible of good fortune? It's the relationships you build along the way,
Right.
and both professional and personal. And I mean, some clients can be a real pain in the neck, and and they have problems. What do I have a inquiry. I mean, I can talk and talk. I have a inquiry. When I'm dealing with somebody who seems to have a mental impairment. How do you provide these people with proper legal services?
Right. Right can be very demanding.
Well, yeah, because they don't understand some things, and sometimes it's difficult because sometimes these kind of impairments are latent. They're not readily visible, and so you've got like a group here, the traumatic brain injury group, that
Right.
the people who specialize in those types of injuries, and but there's just a whole lot to it, and I would say to the young lawyer, the person who's starting out, if you don't really love it, if it's not something that it's something that it touches you in the core of your being, let it go do something else, because it's going to be a miserable, hard life. Because when you're carrying, because what you do, you pick up the weight of other people's problems, and hey, and you have problems too. I mean, we all have problems.
Right. Understatement. Absolutely.
How many languages do you speak?
I speak 4. I've studied 7.
I speak 2.
What other language do you speak?
Redneck.
How would you introduce in redneck? Can you tell me that one?
Watch it. All right, here, I'll show you.
You gotta guess.
I'll show you. Here you go. All right, so here.
All right, I'm gonna This is Besiana trying to speak in Southern. Mr. Ducks, Mr. Not Ducks, Osar CM Wangs, Mr. Ducks.
No, that ain't the.
Did I do it wrong?
You got.
I got it all wrong.
You got an F. All right, are you ready?
What do
Are you ready?
Yeah.
All right, so here you go. MR Ducks, MR Not Ducks, OSAR, CM Wangs, MR Ducks. Well, you.
Thank you for the laugh. I love that. That was perfect.